Hi, Armando Roman here today with Rob Royal, a litigator with the firm Tiffany and Bosco here in Phoenix. Rob, how are you?
Good. Thank you for having me.
Certainly. Rob, you and I had a conversation recently, and as a result of that, it just seemed really important to be able to share your expertise and experience with our listeners. And just a quick recap on our listeners. They are people who own businesses. They founded the company. Typically, sometimes they buy it, but they're the founder, business owner, entrepreneur. They've had this company, say, for maybe 20 years or so. This company represents the biggest chunk of their net worth. And at some point, within the next 5 years or so, they're thinking they will be exiting this company, and that's going to produce their retirement money, and that's going to help them live that legacy that they want to. So, Robert, you and I talked about your experience and expertise as a litigator. We talked about a lot of things that could potentially derail that business owner's plan of say exit in 5 years. And I just want to share with our audience what we talked about, and I'll bring up a couple first. Uh, One of the big things that you mentioned is an operating agreement. But before we go there, if I may, not everyone really knows what a litigator is. As an attorney who is a litigator, please explain to the audience what that really means.
Yeah, thank you. Be glad to. As a litigator, I really focus on business litigation with a unique niche in business divorce. And so, like marital couples that may have conflict at times, business owners who have conflict, I represent either side of the business owner dispute or perhaps the company and trying to solve their issues. And so, being a litigator in that arena involves a number of things. First of all, you've got to meet with your client, understand the facts, and apply the law to the situation given. But one of the most important things I tell them as a litigator is you really don't want to litigate in trial in the court system or otherwise if you can avoid it. Your best option is always to try to reach an agreement that both sides are satisfied with, and that'll save you some time and some money and some grief and some emotion and a roller coaster of a ride in litigation. So I think that's kind of the first thing litigators do is understand everything and try to negotiate a resolution of a dispute. And then if you can't negotiate a resolution of the dispute, then you may be left with no choice but proceed to the court system, or perhaps if there's an arbitration clause in an agreement or by agreement otherwise, into an arbitration venue in which that case your dispute is resolved by an arbitrator, where if you're going to be going into the court system, it's likely that a jury will decide your dispute. And then ultimately you're going to have the trier of fact, the jury or the arbitrator decide everything, and maybe it'll come to an end at that time.
Okay. Okay, I think we might have lost you on camera here. That's a good
Yep.
background, though, Rob, to help us understand. So, what you're saying is that as there are disputes between business owners and partners, or maybe companies to other companies, those disputes can end up in court and become battles, legal battles, where now they have to engage an attorney. Each side gets their own attorney or own representation, which, of course, can be quite expensive. And you said the best thing is, if at all possible, never get to the courtroom, settle well before, and even before that, get your documents nice and neat and clean and organized and communicate well so that you never even have that. So with that, let's talk about one of the things you mentioned to me that is one of the documents that you see as being key to avoiding some of these disputes or minimizing the impact of a dispute. And that document is the operating agreement. Talk about that, if you would, Rob, about how that can help avoid some disputes or minimize the impact of some of those disputes.
The operating agreement is really an essential document for limited liability companies. By far, most entities that are formed these days is a limited liability company. And if there's more than one member, then it's very advisable to have an operating agreement, because the operating agreement sets forth the rules of the road, the rules of operation, the structure of the company, and determines rights and obligations between the members and the members to the company, and then the managers to the company and to the members. And so there's a number of important provisions in any type of operating agreement. And one in particular we want to talk about is with respect to management. So regarding management, it may be a member managed, which means the members are the managers, or it may be a manager managed LLC, which means that the members appoint a manager who could be a member or may not be a member to be the manager of the entity. And so that helps align an understanding of what the management is, and then the operating agreement outlines the duties and responsibilities of the manager. A second very important provision has to deal with what protections the managers are going to have with respect to their responsibilities and obligations to the company and to the other members. And the Arizona Limited Liability Company Act gives some guidance, and people like to write that into their operating agreement so the manager really understands their duties that are owed, because that can be an area of conflict and dispute. A third area that is important is with respect to what if some member wants to leave the company. And situations come up that are commonly put in the operating agreement that say you can't transfer your interest, but if certain things happen like your death, a bankruptcy, creditors are chasing you, they don't want to become part of the company, and your other member partners don't want them to become part of the company. And so those are called trigger devices, triggers to buy out the interest at an agreed upon or otherwise set formula. So the triggers that I encourage and like to see the most if someone wants to leave is just that if someone decides to leave the company, they will have their interest bought out because they've invested time and money, efforts to build a company, and then something comes along. For example, a member of a company may want to leave because his father has asked him to come join him in his business. So there's a very innocent reason to leave the company, and you don't want to just leave everything you put in the company behind. It's not fair to you to do that. And so just a triggering device of a buyout based upon someone leaving the company is, I think, a very important clause to have in the operating agreement.
Yeah.
So those are the principal areas of an operating agreement that I think need to be looked at and settled in to help avoid the conflict leading into some type of litigated dispute.
Yeah, that makes a lot of sense. I had a conversation last week with a business owner who has a health issue. He and his partner have been there for a long time, but now this health issue is requiring the person I spoke with to now step out of the company and work about half time. They have no provision in place for a buyout for this situation at all. And so the conversation that he and I had was, well, how do we make this work? How does he step out of it? How does the company stay intact without his skill set and experience? And how does his family get what he has built over the last 40 years with his partner? How do they get that value into their pocket while the partner is having to step out because of a health issue? And just what you said, had that been addressed in the operating agreement, maybe there would have been a formula, maybe there would have been something that would have addressed this, and it wouldn't be a big gray area that now hopefully can be amicably resolved. But we always, we just don't know what to expect at times.
No, you don't. And when a LLC is formed, that's usually when your operating agreement is done. And of course, it could be changed or amended as time goes on. And there's sometimes good reasons to do so. But at the beginning of the company, or when things are going great, everybody's happy with each other, and people can enter into agreements much easier than something comes along, like maybe the health issue, and the other partner doesn't, agree with what the person suffering the health problem wants to do. But if you have that in place to begin with before any of these issues come up, it's a plus.
Yeah, thank you. Yeah, that's very sound advice. Thank you for that. Talk about, if you would, Rob, a buy-sell agreement. You mentioned a buyout formula. You mentioned triggering events in the operating agreement. If they don't have those things in the operating agreement, but maybe they have a buy-sell agreement, what is the intent? What is the idea of that buy-sell agreement?
Well, a buy-sell agreement can be in the operating agreement. It can be in a separate agreement. It can exist in a number of different ways, but The basic idea of a buy-sell agreement is that if there is a trigger that I mentioned earlier, or if there's a reason that there's an opportunity for a person to be bought out. And that can be in some type of formula. As I mentioned, it could be based on the financial condition of the company. There's a number of ways, from a fire sale to something called fair value that gives you a value for what that buyout might be. But it's really a document or an agreement intended to take care of those situations when something has happened, whether it be a health condition or a death or a divorce or something like that, that the other partners believe that it's a good idea for the company or maybe other owners to buy out that interest. So their partnership between the owners that they want to be partners with is preserved. And that's how one buy-sell does work. And there's other ways to set up other buy-sells, like something called a shotgun buy-sell.
Yeah, touch on that if you wouldn't mind. When you say shotgun buy-sell, what does that really mean?
A shotgun buy-sell is really an excellent device, in my view, of trying to solve a dispute about the value of a buyout. So it's not necessarily disputing a buyout situation. It's existing when one person wants to buy out another. And that can solve the dispute, that can solve the conflict.
Okay.
And I've utilized that opportunity on a number of occasions successfully. And what a shotgun buy-sell agreement does is that if you and I are in a partnership together and we have a shotgun buy-sell, I've decided I want to leave and you don't agree on the price and you're happy to have me leave. So I say, okay, I am going to go buy out your interest, Armando, for $100,000. But the shotgun buy-sell means that you get to buy my interest out at the same price of $100,000. And so what that forces the parties to do is to come to a fair price, knowing that their interest under the shotgun buy-sell can either be bought or sold by the other party involved in the transaction.
Okay. So if you
So
made
it
me
is an
offer,
effective device.
okay. So if you made me an offer, sorry, I didn't mean to cut you off there. I just want to clarify for the audience. So if my partner made me an offer to buy me out for $100,000, and I say, Rob, that sounds great, but no, thank you. Then I can turn right back around and say, I'm going to now buy you out for that same money that you offered me, that same price.
Yeah, exactly. Because you would say, wow, $100,000. I
What a
don't want to
bargain.
buy him out for that because I see that's a very low price. So I'm going to buy him out because I'll get a better deal than him buying me out.
Yeah.
So that's what forces the adjustment and makes the price fair.
Yeah, so it makes that first offer by the partner really more of a fair market offer versus a lowball offer.
Yeah, and a lot can go into that. Over the years, I've seen many examples of one client, for example, said, I know my partner will never be bought out, that this partner will insist on staying in, and this partner enjoys the publicity that comes with the position. And so we're going to up our price. And we upped our price. We made the offer, and he was exactly right. She wouldn't be bought out, and she bought him out for that higher price.
It sounds like the partner who is thinking of buying the other one out better be prepared to also get bought out if he's going to do that. Would you call it a shotgun buy-sell? Is that what you called it?
That's exactly the point. You better make an offer if you're starting it to know that they could buy you out for the same amount.
Okay. So another concept we talked about in our previous conversation was about being a fiduciary of the company, not to the people or really to all stakeholders. Talk about, if you would, Rob, the fiduciary role. And again, you as a litigator, you're in the courtroom representing your client, trying to help your client get what they think they should be getting. How does that term fiduciary, that role fiduciary, how does that play into these businesses?
The fiduciary concept is one that's in many places in the law, including in the corporate setting. The fiduciary duty is when one owes to another the highest duty recognized in law, the utmost good faith, fair dealing. You're acting not for your benefit, but the benefit of those to whom you owe the duty to. You can't act in your interest. You have to act in the person that the duty is owed to their best interest. And it's designed to protect everybody with respect to the operations in this scenario of a company. Because in a LLC, the managers owe a fiduciary duty to the company because they want to act and should act in the company's best interest. And to do so, you have to be informed about the facts and make informed decisions for the benefit of the company. And therefore, you have what's called a duty of care, to act in the best interest of the company. Mm-hmm. You also have a duty of loyalty to act in the best interests of the company. That means you can't take advantage of the company for your own benefit. And the duty of loyalty, the duty of care, and the duty of disclosing to everybody that needs to have the information are all important concepts within the fiduciary duty. So from my perspective, it is the primary duty governing the relationships of members and managers, owners of the company, in addition to an operating agreement. And those two things are what drives the rights and obligations to exist in a friendly, cohesive environment designed to further the primary purposes of the company and all the members to hopefully a successful situation.
Okay. And so is that just getting back to the audience who's thinking of exiting, of somehow transitioning out of their company in the next 5 years? They want to have a smooth sailing to that finish line, to get to that promised land that they want to get to. And as we have this conversation, we're touching on areas that certainly could derail that path, or put speed bumps in that path, or maybe just totally destroy that path if some of these areas really aren't given the full attention that they need. And you as a litigator, you've seen that, of course, in your work. Let me ask you then about another area that we talked about. You talked about communication and making sure that in the company, communicating, and you just touched on it again just now when you talked about full disclosure, about that communication. Talk about, if you would, Rob, with business partners that are taking a business forward along that same mission, those same goals, and that how a lack of communication can lead to them getting into the courtroom when neither one of them really wanted that or expected that.
Path to a successful sale over, like in your example, a 5-year period, is one that it's essential to fulfill the rights and obligations of a fiduciary. That's very important. So how does that relationship between members start to break down? And it really begins from what I've seen with communication. As I mentioned, there's a duty of disclosure, and then the lack of communication starts to violate that duty. And so the person that's controlling the business records and the finances of the company doesn't keep the other members apprised of what's going on. And of course, they have every right, including a statutory right and under the operating agreement, to inspect the books and records. But sometimes, partners hide things for their own desires, because of their greed, because of their power, whatever it might be. And then somebody finds out about it. And so the communications are then starting to break down. Okay. And they go to the person hiding the books and records and says, let me see them. Things are going on I'm not sure about, and I need to look for myself, and you're not keeping me informed. So I need to look at those books and records and finances. And if there's hesitation, that is a problem, because with lack of communication and transparency in the finances of the company, there's going to be an element of distrust. So with lack of communication comes distrust. Okay. And I think that's when the relationship's conflict starts to build, and it will increase if it's not nipped in the bud. And that's why our Arizona laws require any member of an LLC to have free access to the books and records on limited easy conditions to meet, because they need to understand what's going on and communicate about what the business operations are from a financial end. And of course, there's also the management side. So if persons are making significant management decisions without consulting their partners, as required by Arizona law or the operating agreement, what happens? Again, there's a lack of communication, and then there's distrust. So that is it. From the management side, that also contributes to the lack of communication causing distrust that starts the breakdown of communication, and therefore the conflict begins to increase.
Okay, that makes sense. Full disclosure sounds like it is the best way. And as you told me before, making sure that there's communication freely, frequently. And I think you said, don't be afraid to communicate because that helps people understand and build that trust. And it's just a better way to go. So I think you told me you've been in the courtroom for, I don't know, at least 30 years, if not more than that, as a litigator. And you've seen many, many things that have snowballed into litigation that could probably have been nipped in the bud before they ever got to that point. And some of them, I'm sure, are fairly little, tiny, innocent things that just snowballed. So we touched on the operating agreement and the responsibility of managers and of members, what they should see. What are some of those things, Rob, that we haven't touched on yet that you've seen maybe snowball into a full-blown litigation that could have been avoided had the right steps been taken along the way before they got there?
Yeah, let me start by summarizing a little bit. Your operating agreement is providing you guidelines and rules of the road, and paying attention to the operating agreement gives you a chance to be able to smooth things over by taking the operating agreement and talking to your partner. Just common sense, of course, sits out there, and understanding just as a friendship and what partners would expect of each other, because one partner is putting their trust in another. And the trust means I trust you to take my money to use it wisely in this company. And I trust that you'll listen to me in management decisions. And, you may be in a position where you can't control the decision. So the majority owner or the majority of the management may have a position that you don't like, and you need to voice your opinion. So when you start from that kind of foundation and groundwork, it is little things. It's usually little things like, you didn't tell me that you're going to pay for your daughter's wedding out of the company account. True story. and I would have liked to know that, because half that money as a 50% owner is mine. And so
Right.
don't do it again. And that might be enough to nip it in the bud. Talking with an accountant about the finances or tax returns and questionable items might nip it in the bud. Having regular meetings or communications might start nipping it in the bud. But what starts to happen, and as part of this fiduciary concept that we litigate, we are usually taking a series of actions that are just bad actions, bad activities, because they do roll into a snowball, and they make that snowball bigger, and you want to start that snowball rolling downhill, picking up more snow as it goes, because that will help build your case for a prosecution of this kind of claim. And so it's really avoiding these minor things and a repetition of the minor things that will probably aid your person in moving forward into a sale or getting in position to sell 5 years down the road.
Okay. And Rob, let me ask you, you mentioned a series of actions, building a case. For someone who has not been through litigation before, maybe you can just walk through what those steps are, because you just talked about building a case. What does that really mean? So if you wouldn't mind, walk that founder through, you as a litigator, what does that mean you're doing kind of step by step, building that case, helping to help your client hopefully get the resolution that they want, so that the listener can really understand why that written signed operating agreement is so darned important, as well as having all that documentation that you've talked about.
Well, as a founder of a company, and for my answer, I'm going to use it as a founder of a family-owned company.
Okay.
The founder comes into my office and they've got a problem. And in advance, I've asked them to provide me the key documents that relate to the company. So I'll probably see articles of organization and an operating agreement. I ask them, bring me any other agreements that exist. It might be an employment agreement or other kinds of things.
Okay.
And so I can assess and understand first the structure of the company, and then I hear the facts that he tells me or she may tell me. And then that founder is seeking my legal advice. What do I do? That's their question. What am I going to do at this point?
Okay.
And so I will start to counsel them about their legal rights and obligations, the risks, the rewards of dispute resolution. I'm going to talk to them about a general plan of, first, you want to go try to negotiate this. Second, and we might probably have to do that by issuing a demand letter by the time it gets to me, to point out your position and the wrongdoing of the other. And of course, when I'm on the other side, I'm going to receive that kind of letter and do the same kind of thing I'm doing now to defend the position. But anyway, that founder, then I'm going to counsel them about avoiding litigation. I'm going to counsel them about the techniques in litigation to reach their goals and the means to get to that goal with or without litigation. I'm going to talk about other dispute resolution processes that are available besides litigation in the court system. One of them I mentioned is arbitration. Another one that's very big today is known as mediation, because that's pretty prevalent in our line of work. So, excuse me, I'm going to lay out for him, what is involved in the future and the pathway that's going to take, if you're going to go in the court system, 12 to 18 months to get resolved.
Okay. So you help them walk down that path in their minds so they can see what that looks like.
Yeah, exactly. And then you're going to develop strategies to meet those goals and create means to reach those goals in the best way possible and without expending resources that are unnecessary, unless, because of failing negotiations or whatever, the other side is forcing you to spend more time and money to get a resolution, or maybe you're just unsatisfied and you need to take the steps to get what you deserve.
Okay. And your starting point with that was getting actual you said employment agreements, operating agreements, articles, any signed agreements then you can see what documents exist.
Yeah, it's important because I need to know what the lay of the land is and what the rules are and the guidelines are that are set forth in these documents, besides the law, which I know. And so that helps to me formulate both the factual and, more importantly, the legal plan, utilizing legal processes that are available. And from a factual standpoint, understanding what the pressure points are for purposes of negotiation to try to solve this before you have to file litigation.
Yeah. So Rob, let me just, for the listener, let me clarify. Let me emphasize the point that you just said. When you're representing your client, of course, they're telling you what from their perspective, what they see, what they think is happening. You are then looking at all those written documents, and then you're helping them understand what you see versus what maybe they're thinking or they're seeing. And then you, as their attorney who's going to represent them in that courtroom, if it gets to actually a courtroom, you're telling them, this is what you should expect. Let's try to get a mediator or arbitrator, or let's try to just settle this without ever going to court, because that's gonna be a lot less painful and a lot less costly. But your starting point really is, what are those documents that have been signed? Because that's just how important those are. You're starting there, you're building from there, right?
Yeah, exactly. They are extremely important, and they really need to be done up correctly. And getting a lawyer that can handle that for your founder is very important, because believe me, I've read handwritten operating agreements, agreements that parties make up on their own, agreements that they pull forms from all kinds of places. I've seen operating agreements from an online service that, it might be okay, but it doesn't deal with their unique situations. They're not unique for their particular situation. And so an operating agreement that's well written, that covers the waterfront, I love to see those, because that is going to help solve things a lot better and a
Yeah.
lot faster.
Yeah. And it sounds like, as you describe what you described just now, I couldn't help but to think of a prenup when someone's about to get married and one of the spouses to be has assets, significant assets, and the other one maybe doesn't. But the prenup lays out ahead of time so that there is some kind of a not dispute, maybe it's a divorce, but then you know what it's going to look like because you've already predefined all of that.
Yeah, I think there's a good analogy being made there. So, like, if the marital partners in their prenup have decided if things go bad and they divorce, this is how it's going to work out. And the operating agreement has the opportunity to do exactly the same thing. And so, if the founder comes to me and says, in my family business, these things are very disturbing to me, and I don't want to be a part of this anymore, I'm going to say, well, let's take a look at your operating agreement and see what it says, and see, like a prenup, whether it outlines a process for you to step out on a fair basis and receive from those that are left or the company what is a fair buyout. Very much like a prenup.
Okay. Yeah, and it's interesting. In Arizona, we're of course in Arizona, each law has its own LLC laws, as you mentioned earlier. And it's pretty easy to start up an entity, a business entity in Arizona, even online without ever talking with an attorney, without ever talking with the Arizona Corporation Commission. And people can do this all the time. They get online, they fill out the forms, they pay the fee, and now they've got a business. But if they do go online, Rob, as many people do to do that, and I'm sure you've been through that yourself, as they walk through those steps, at no point in there is there an operating agreement that comes out of that process. So it'd be real easy for the business owner to not do it at the beginning, forget all about it till later, till it matters, and then be in trouble.
Yeah, that's a good point. Yeah, it is. Of course, takes a few minutes to fill out the articles of organization online with the Arizona Corporation Commission and become an LLC. And a lot of people starting on a shoestring budget or less, that's what they're going to do.
Right.
And, I understand that, and that's fine. But there's going to be a period of time that may go by that you wish you had an operating agreement. And that really should be, if you can't afford it to begin with, it should be one of the first things you later put on as the company really becomes viable and you're starting to see it go. Get that thing in place when the company and all the owners are happy about the progress of the company and where it's going, because it really is essential. And so if you do not have an operating agreement, then you are governed by the Arizona Limited Liability Company Act. And when we wrote that a few years ago, we took great pains to put in provisions to help an individual, help the less experienced attorney to examine what should or should not be in an operating agreement. So there's good tips in the Arizona statute about whether an individual or an attorney can go to that statute and they can see what are some good tips, what's important, the do's and the don'ts of an operating agreement. So even though you may start off with filling out the form, there's going to be a time either at the beginning or after the company's starting to roll along, and you really need an operating agreement.
Yeah, yeah. So what you're saying is it's not too late. Even if, like you said, on a shoestring they began the company, but maybe now it's gaining some traction. They're getting some employees. Maybe they're bringing on some additional help that they're promising equity along the way or something like that, that they can still get with an attorney who understands the space, obviously, to draft an operating agreement that really makes sense for them with that company going forward.
Oh, exactly. The founder or founders of the company they just need to get that done. And so when you are 5 years away from the sale, one of the things that anybody interested in buying that company is going to want to see is a solid operating agreement, uh, because that is the standard level expected of a sophisticated buyer. And so that's part of getting things in order, making sure you have that solid operating agreement in place, including provisions taking into account the sale of the company and what that may mean.
Okay. And Rob, can you talk about, we talked about partners. We've touched that a couple of times in this conversation so far. What are some of the common areas that partners, just maybe not relatives, not a husband, wife, not two brothers, but just two people who know each other, who partner and go into business together? What are some of the common disputes or things that cause disputes that can lead to them ending up at your desk in your office because now there's a problem?
With all the different kinds of companies and people involved, believe it or not, there are common themes that I see that you can just kind of fill in the theme based on the facts of that particular case. And so one of those themes is that they're hiding information from me. And that's just not good. And that's leads me to demand and request an inspection of the records under Arizona statute.
Okay.
That's pretty easy stuff. A second area is they are taking money out of the company for their own use.
Okay.
And part of that's mine. The earlier example of the owner that paid for his daughter's wedding from company funds.
Yep.
It's very common in most closely held companies that people take small or perhaps large liberties of utilizing corporate funds for personal use under the guise it's a business expense. They go to Home Depot, another common thing, or they have a charge card. So they go like to a Home Depot and they buy 2 things for the company and 20 things for their house. And the company pays for it. That's a small example. But the examples can, grow in size based upon how those company funds are being used for a personal purpose. Another common theme is that somebody is trying to take a company opportunity, or they're trying to compete against the company somehow.
Okay.
And, as a partner, I don't want to see my partner competing against the company I'm a member of. So that is another common theme that it comes up, but it kind of all rolls into the same ideas of, number one, you have an expectation. It's a reasonable expectation, doctrine and law, but you have an expectation that as an owner of this company, you're going to be employed and you're going to get a return on your investment by being employed. You're going to have an expectation of active participation in management. Mm-hmm. Because, hey, I put money into this company. I work for this company. I'm a 40% owner. I have a say. And third, you always have an expectation if the company does well, you're going to get the profits from it. And someday if it's sold, or glory be it goes public, you're going to get a return on that. And so these are very common, understandable expectations that every business owner has. And so those expectations start to get defeated. I'm making decisions without your input. I don't want your say. I'm a majority owner in this company. I can say and do whatever I darn well please, which is not the truth. That is not the law. So majority, you got to know the duties and obligations you have to the others, including minority members.
Okay. Good. Well, thank you. You said common themes, hiding information, taking money out of the company, competing against the company. You used example of the paying for the daughter's wedding. Weddings are not cheap, but you'd think you'd notice a big chunk of money.
That's for sure.
Yeah, I guess if you go get married on the beach and sneak on the beach and do it before anybody knows, then it's going to be inexpensive. But that's the exception, not the norm from what I've seen out there.
Oh yes, I've been through one of those weddings.
Yeah, and so you also mentioned about taxes, having, like you said, Home Depot, buy 2 things for the company, 20 things for the house. And I think that one of the things that, having having had a built and sold a tax practice that I sold almost 20 years ago, the number one thing you hear as a tax practitioner from your client is, how do I pay less taxes? I'm paying too much taxes. How do I pay less? And so there's often this tendency or desire to take those gray areas, like your example of buying more from Home Depot for the personal use and running it through the business. And maybe if somebody has been doing that for years and now they bring in a partner, sounds like they have to understand, hey, that has to stop. It's
Yeah,
different.
it does. The other partner is going to be upset about it. And I'm not here to pay part of my profits to fund your Home Depot purchases. That's not the way it works. We are in this together for the benefit of the good, the benefit of the whole, the benefit of the company. And we got to be fair to each other. And I put my trust in you as a confidential business relationship that you have some control over the money and you're going to do it correctly. That's particularly true when there's a passive investor and then an active person in the company, or it's particularly true in a majority minority situation. Because the majority may think that they can do whatever they want, including on the finances, and take money out whenever they please. But that ignores the fiduciary obligation they have to the minority to help take care of the minority's financial interest that they put in this company in order to have the minority then prosper and have those reasonable expectations of employment, a reasonable return on my investment come to them.
Yeah. It sounds like you have to educate people, you in your role, as a litigator, that I imagine you educate people to things they just completely were not aware of at all because they just didn't know, which again,
Yeah, they don't
back
know.
to on day one, they need to get that advice and counsel so that they don't get blindsided later.
Well, I think it's important from day one or as soon as possible that you understand your fiduciary obligations, that you understand what these obligations and duties are written into an operating agreement. And understand, I mean, it's deeper than reading it. It's really understanding what it's all about, where you can go off the rails as far as those duties and obligations, because you want to make sure your company's not falling off the rails in that 5 years leading to sale. And you want to make sure your company and the owners are running smoothly because people do not want to get involved with a company when the owners are battling and they're
Right.
feuding and they're fighting.
Right.
Nobody wants to get involved in that. And you got to take a lot of protection to make sure you got to save the golden goose or the company from your conflict getting out of control.
Right. And then leading up to sale, say if exit is intended, say in 5 years, the buyer wants to see very clean financials. They don't want to see those extra purchases at Home Depot. They don't want to see daughter's wedding, and they don't want conflict. So it just emphasizes again that bookkeeping, that accounting has to be as clean as possible, those financials as clean as possible, those tax returns as clean as possible, meaning get anything that's personal out, just take it out. And when there are partners, it's better, and sounds like it's best practices anyway from what you're describing, that they don't include anything that's personal at all anyway. It helps the partnership function better and helps them both get, say, two partners get to that sale the way they're trying to get to.
Well, you're exactly right. And you're probably familiar with the term of normalized earnings. That's what we're talking about here. The company wants to see what the true earnings are the company. The buying company, excuse me, wants to see what the true earnings are.
Yeah.
And the only way you have the true earnings is to have clean records, clean books, clean financials.
Yep.
They want to make sure there's been no hanky-panky that's gone on within the company. Why? Because that will lead to inaccurate records. It will lead to potential claims. It will lead to disputing partners interfering with the sale process. You don't want that. You want your company clean and green as it's approaching into the sale process and to get ready for sale.
Right. Exactly. Yep. And that's just so important. It's just so important. I have this conversation with business owners at times where they have their focus has been to minimize the taxes they pay, and that's the mandate that they give to their tax preparer, their tax CPA. But then they are now, say, 2 years out from sale, and they still want to pay less taxes today, but that might actually cost them in terms of the valuation of the company when they sell in 2 years. So they've got to flip that coin over and instead focus on showing as much profit as possible and having those books and records clean and organized, so the buyer sees what the buyer wants to see and they pay top dollar, top value for that business when they acquire it.
Real good point there. Flipping the coin. If that needs to be done, you better do it.
Yep.
It's not only the financial records, but it's also the management. And management conflict has to be eliminated. It's good that management structure is put in place, like, for example, regular meetings, that you're following procedures that need to be done, that the regular meetings are producing minutes and documents are being done to document transactions. There's not just some handshake deals. And then management is, if it's, I'll say, the management of the founders, demonstrating that the founders' management has been competent. Or maybe the founders have decided to bring in professional management, as I call it.
Yeah.
Professional management that's been down that road before, that has the experience with other companies to manage this kind of company and to put that company in a position for sale at the best price.
Yeah, exactly. And if you could, Rob, you mentioned getting, I forgot how you phrased it, but you said something about sometimes people get online to get operating agreements. When they start, maybe they grab one off the internet. Now we have, of course, artificial intelligence, where you can tell it what you want. It'll create a document for you that looks, to the non-lawyer, looks, hey, that looks pretty good, let's go with that. But as we've been finding out with artificial intelligence, it has these hallucinations, it puts in bad information, it gives wrong information. But you can see how easily it would be for somebody who's not a lawyer like you, who wants that operating agreement and just want to pay a lot to get it. They could certainly get one online and have an agreement that really is not going to serve them well, because they just don't know. So your point about getting the right counsel to help you understand and draft that agreement that really makes sense for you and your company and the business that you're in and that you're going to be running is just so much more important. I imagine maybe you've seen some of those online documents or those AI created documents that really don't serve the business owner well, and now they're trying to fix it, but now they're already in some kind of a dispute or litigation, and it's kind of too late.
Yeah, I'd be glad to comment first on AI, and it has a real place. It's redeveloping and reshaping the law, that's for sure, including my litigation practice. But on the other hand, there's already been judges and things happen within a court system and in other circumstances on the transactional side that has demonstrated that forms are good. Same old thing for many, many years. Forms are good, but they're not cut out for you. They're cut out for the average person. So while AI will create an operating agreement for you, I'm sure I've never done it. I think that operating agreement might be 50 or 60% of what you really need. It's not tailored to your situation. And so I have seen operating agreements brought to me that weren't done by AI, but were forms they thought worked. And I would say 100% of the time, I'm seeing that because it wasn't tuned for that person, that owner, I have to tell them that, well, this is not the way you want it. This is going to create a problem for you.
Yeah.
That's not giving you the rights that you deserve because you did a form. It doesn't fit in your industry, in your business, in your profession, in your practice. There's all kinds of ways that forms don't fit into your needs. And so even starting with a form, okay, fine, but you better get it looked at some point in time before the company really starts to roll.
Yeah, and you said that, for the average person that form might work, and it's interesting, the we use that word average at times when we talk about mortality. The average man will live today to about age 77 or 78. The average woman will live to about 80 or 81. And then when I'm in an audience, and I'll ask people in the audience, okay, how many of you are average? Well, none of them are average.
That's right.
Nobody's average. Yet we use these numbers and we use these standardized forms for the average person. But as you said, it really has to be tailored to that person in that business and what they're really trying to get to.
Yeah, no two businesses are alike. Um, if you look at a franchise concept, franchisees sign the same agreement that everybody has, all the other franchises, so the franchisor has control and it's all the same. And, to a point that works because your relationship is between franchisee and franchisor. That's fine. But you know what? You're in your own business as a franchisee. It's you and your partners. And it's what's best for you in that franchise situation.
Yeah.
So even in circumstances where there is some uniformity, it still is not the same as your business with your partners.
Yeah, no, that makes a lot of sense. And so, Rob, this has been a great conversation. We talked about the significance, the importance of the operating agreement. We talked about buy sell. You can build that into the operating agreement or have a separate agreement to accomplish the same goal to buy out with the buyout formula, having triggering events in there that will maybe not automate, but maybe they do automate some things that can happen or certainly might need to happen. You mentioned a shotgun buy sell that I like that idea that if one wants to buy out the other, they can certainly make an offer to one, but if that offer is declined, then they are required to accept that same offer because that's the offer that they themselves made.
That's right.
The shotgun buy sell sounds a little bit terrifying at the same time. Talked about fiduciary, about having the duty of care, having full disclosure, and how important the word fiduciary is for the company, giving full disclosure, communicating well, and communicating often. And you just touched on so many areas that are relevant to this business owner. So thank you so much for that. You, of course, are in the courtroom as a litigator when there's a problem. As you said, you don't really want to get to the courtroom. You'd rather resolve that dispute with mediation, arbitration, or some way to amicably resolve it without having to go through the court system. That's better for your client. It's going to cost them a heck of a lot less and a lot less stress and anxiety as well along the way. And I just appreciate you sharing your expertise with us, Rob. Is there anything that we haven't touched on that founder thinking of selling in the next 5 years that he or she really might want to think about as they've got this experienced litigator here in front of them?
Yeah, I think I touch on one final thing. As the founder is preparing to get the company ready for sale in 5 years, and the founder is looked at and examined the kind of things we've talked about, in order to avoid or resolve conflict. That's really what we've been talking about. But along the way, if there is some conflict that's out there, and to preserve the company in its best position possible in order to get ready for sale, there's a few things that I've counseled my clients on and how to avoid other conflicts, if you would say it that way, and to keep conflict from hurting your company. From number one, I mentioned already, is you don't kill the golden goose. So even though you might be in conflict, you don't want to do anything that's going to hurt the company, because the company is the golden goose, and hopefully the gold is at the end of the rainbow when it's sold. Secondly, it's best to keep owner disputes away from employees, because employees are going to become dissatisfied. The morale is going to go down. Some key employees might leave. And, the dispute is between owners and should not involve employees. Similarly, customers don't want to do business in a company when the owners are making public their fight. They just don't want to be part of it, and they see that the company, because of the fight, may not be delivering the product or the service they come to expect. So keep your dispute away from customers. Keep your dispute out of the hands of vendors and others that work for you that don't need to know about it, because they're not going to want to do business, or they're all of a sudden going to put you on a cash only basis when you can't do that.
Yeah.
Or they're going to take steps seeing trouble to protect themselves. And so protection of the company, to sum it up, is very important as you participate and work to resolve the conflict. So the company, again, is in the best position to get the highest price when that sale date arrives.
Yeah, that's excellent, excellent advice and counsel on that. Thank you so much. It sounds like what's that expression? Don't air your dirty laundry. Is that how that expression goes?
That would work, yes.
Keep it quiet, get it clean, and then just keep it to yourselves if there's some kind of
It'll
an
be
issue.
for the best, for sure.
Yeah, well, Rob, thank you so much for the conversation. Really appreciate it. And just appreciate all your expertise that you've shared so freely with the people who are in business and trying to get to that, say, 5-year mark of selling their business and having that, happily ever after moment they're trying to get to when they go through that transitional event in the company. So again, this is Rob Royal with the law firm of Tiffany Bosco, very experienced litigator. Rob, thank you so much. Really appreciate the time with you.
Thank you very much, Armando. It was a pleasure to meet with you and discuss these subjects today.
Perfect.